Hello, guys. Becoming a U.S. citizen involves meeting several naturalization requirements. Some of them are technical, such as the residency requirements, while others are more subjective. One of the key requirements is providing proof of good moral character. People who are applying for citizenship often fear that receiving public benefits may undermine their proof of good moral character. However, this concern is unfounded. Unless you illegally receive the public benefits, receiving them will not affect their eligibility for citizenship. What are public benefits? Public benefits are government benefits like food, cash, housing, and medical assistance for people with low or no income. For examples, SNAP, food stamps, TANF, public housing, and Medicaid. What is a public charge? A public charge is a non-citizen who is primarily dependent on the government for support by receiving cash assistance or long-term medical care. If the government determines that you are likely to become a public charge at any time in the future, you can be denied a green card, also known as lawful permanent resident status, a visa, admission into the U.S. Under the rule, USCIS will look at these factors to decide if you are likely to become a public charge: your age, your health, your family status, your education and skills, your assets, resources, and financial status, and whether you have gotten cash assistance in the past. Who does the public charge rule apply to? The rule only applies to people applying for a visa, green cards on certain grounds, and people seeking admission to the U.S. from abroad. The public charge rule does not apply if you are applying for citizenship, you already have a green card, you're already a lawful permanent resident, unless you leave the country without permission for more than 180 days at one time and return. You are renewing your green card. You are replacing your lost or stolen green card. You are a naturalized citizen. You are applying for a U visa, T visa, special immigrant juvenile status, refugee/asylee status, or a VAWA. You are applying for a green card based on an approved U visa, T visa, special immigrant juvenile petition, refugee asylee petition, or a VAWA self-petition, or you have a U or T visa, special immigrant juvenile status, VAWA, or asylum refugee status. If you are in one of these categories, you can use any benefits you qualify for, including cash aid, healthcare, food programs, and other non-cash programs. What if my child gets benefits? The government will not consider your child's receipt of benefits in your application for a green card. Children who are U.S. citizens are not subject to the public charge rule. Children who are lawful permanent residents are also not subject to the public charge rule unless they leave the country for more than 180 days at a time and return. What benefits are not included under the public charge rule? DHS will not consider the following benefits in a public charge test: Medicaid, Emergency Medicaid, Children's Health Insurance Program, CHIP or Husky-B, and state and locally based healthcare programs for services other than long-term care. Nutrition programs such as Supplemental Nutrition Assistance Program, SNAP, Special Supplemental Nutrition Program for Women's, Infants, and Children, WIC, school lunch programs, and food banks. Subsidized housing programs such as Section 8 and public housing. COVID-related supports such as pandemic, electronic benefits transfer, PEBT, stimulus payments, child tax credits, emergency rental assistance, and more. Other state-based, non-cash assistance programs. Cash benefits based on work or earnings, including Social Security, retirement, pensions, and veterans benefits. What if I need benefits because of COVID-19? USCIS will not consider testing, treatment, or preventative care including vaccines, related to COVID-19 as part of the test they use to determine if someone is a public charge, even if such treatment is provided or paid for by one or more public benefits. Notes: the public charge rule may be applied to green card holders who leave the U.S. for more than 180 contiguous days, about 6 months, and then try to re-enter the United States. I hope this information is helpful for you. Thank you for watching.